Okay. Hi, everyone. I am Elizabeth Steele, Vice President of Programs and Global Affairs at MassBio, and I'm here to kick off today's forum, which is focused on workplace reentry, legal and practical considerations for Massachusetts employers. And we know that this is a topic that is absolutely on the top of everyone's mind right now. And I'm happy to say that we have Jennifer Merrigan Fay, a partner at Goodwin's employment practice, to present to us today. Jennifer has very quickly become an expert in this, and in some cases, she stayed up all night long in order to review the materials so that you don't have to. So before I hand it over to Jennifer, I'm going to encourage everyone to ask questions via the Q&A tab at the bottom, and to make sure that you upvote questions that you would like to hear answered. So Jennifer, the stage is yours.
Great. Thanks so much, Elizabeth. Good morning, everyone. So I promised to try to be as informative as possible in today's session, but I'm not going to promise not to give you some homework, which is to do some of the reading that I've done, and probably a lot of you have done as well. What I'm going to do today with today's presentation is I'll start off with more general principles of employment law as applied to reopening, and then I'm going to focus at the end on Governor Baker's task force and the reopening order, and the requirements that come out of that, including development of a control plan, and we're really drilling down on the the specific sector requirements, as well as how to do the postings and things like that. So we'll start broad and then narrow it a bit. So I can't yet see the PowerPoint, Elizabeth. Can you put that up on the screen? Okay, great. Thank you so much. Oh, I can now see there we go. Okay, so I'm gonna ask you to shift to the next slide, Elizabeth. Thanks so much. All right, so the first thing on everyone's mind, I'm sure, and you're probably well into this task already, which is to develop a reentry task force, and who will be on that task force. And that may change as you move through the process. Everything is fluid, as you know. The law is changing almost every day. The science is changing. Many of us, I know, we're on the CDC website's alert line, so we're constantly reading new things about the virus, about the transmission risk, about the ways in which it's transmitted, including as recently as last Friday, when there was really a focus on the transmission through person-to-person contact, and less of a focus, although not entirely eliminated, but less of a focus on surface transmission. Those are all things that are really relevant to all of us as employers. So making sure that you're developing a plan, you're developing that task force, you have a plan, but you know that you need to be flexible in terms of the way things are going to change, for sure. Leadership considerations are essential, right? So there needs to be buy-in at the very highest level of compliance with the rules that are going to need to apply to the workforce for some months to come, certainly, and making sure that there are the people who are really running the task force is someone who is an effective leader that's going to be able to, number one, delegate, because there's way too much for one or even two people to do. Even at smaller companies, you're going to need to have several different folks that are involved in determining how to put together the plan, as well as implementing the plan and monitoring it. But having a couple of really strong leaders is just essential, using your really best folks for that. And then again, just conducting a risk assessment is one of the very first things. And to conduct a risk assessment, you really want, I get this question all the time, is like, what do we look at to do that? Well, we now in Massachusetts have very, very specific guidance from the state and from the governor's office, and that's been exceptionally helpful to a lot of folks who had just felt like they were spinning their wheels. But I would still start back at the very basics, which is to make sure you're looking at OSHA guidance and CDC guidance. And in particular, OSHA has a document, I think it's about 39 pages, and I'm going to reference the resources in just a moment, that says preparing for COVID-19 or something, words to that effect. We'll get the title up on the board. It's very useful because it really goes through three different segments of risk assessment, right? The first one is thinking about engineering controls, and that means looking at what ways in which you can change things in the workplace. You may need to change things in the workplace in order to keep the transmission risk down as much as possible. It also talks about administrative controls, which are the ways in which you may change your policies in order to decrease the risk of infection within the workplace. And then safe workplace practices, which are the things that all of us are going to be living with for the foreseeable future. Okay, then of course, layering on top of that, starting broadly and then moving down, you want to start with OSHA and CDC, then you want to look at any federal, state, or local advisories and directives as those may develop and change. In particular, those of you who are in Cambridge, I know a lot of the folks on the phone are in Cambridge, you have to worry about Cambridge as well as worrying about the state, as well as worrying about federal guidance as well. Next slide, please. Okay, these are just a couple of the sources that I'm recommending that my clients have not just printed out, but actually on your laptop or pinned down to the bottom with alerts to each one, so that if there are changes, you're aware of those changes. So there have been a number of changes, in particular to the document here called EEOC, what you should know about COVID-19 and the ADA, the Rehabilitation Act, and other EEO laws. That's really essential when you're doing your planning, and it's a document that has changed a number of times. In fact, a couple of weeks ago, they changed it when they were referring to whether or not you could exclude certain classes of employees, including older individuals from the workplace. And they put something out, and then it was, all of us were reacting to it in the employment bar, and then almost immediately it came down because there was confusion. Bloomberg came out with a headline saying that, oh, you get to exclude whoever you want from the workplace, and it's not what they meant at all, and they clarified. So we'll talk about that a little bit as we go on. But I pointed out here because it just shows that just because you don't want to just print these out and say, okay, these are the guidelines, I'm going to go by them, and as long as this is what it says, because they are changing as everything changes with respect to the response to the virus. Okay, so that's the last part about being prepared to move to, and making sure your employees know also that you may need to go backwards or change course at least. Next slide. All right, so this is, again, broad. Many of you are already well on your way on this, which are ways in which you need to make physical changes to your offices and to the workspaces, including by creating barriers, developing and enforcing strict social distancing rules, including by limiting gatherings, adjusting schedules, common areas, and wearing masks in the workplace, etc. I'm only going to, pause on this slide for a moment because we're going to get into a lot more detail when we talk about the reopening order in Massachusetts. Next slide. Reviewing and updating your employment policies is not something that's been specifically addressed in the reopening order in Massachusetts, but it is essential that you look at those policies. Again, many of you have likely already started this process, although many of my clients have told me that they sort of were status quo for a while and just kept hopeful that if they just kind of kept things where they were, they'd be able to get back into the workplace and things would they just be able to return to where they were, including things like flexible paid time off policies. At the beginning of the crisis, people were afraid that there would be too much time off, right? That folks would be using that flexible paid time off to say, well, I'm not coming back until the crisis is over when I can return to the workplace. It's interesting because actually what's happened, and so a lot of my clients have said, can you help us modify those policies? And we did do that. I'm now getting requests and saying, we need to actually get people to stop working a little bit. There's no time off. People aren't recharging their battery at all. We're finding that people are working. There is no difference between Saturday and Wednesday anymore. And that's a problem. I do think that might change a little bit as the reopening is beginning, and as the weekends actually feel like weekends from a weather standpoint, and people are settling into this new normal. But take a look, how are those policies working for you? Does it make sense to make a change, at least a change that says something like, here's who we were, here's who we're going to be, but right now we need to be a little bit different in terms of the way that we have policies. One of my clients just developed a really comprehensive administrative leave policy that relates to, it's a company that has more than 500 employees, so they didn't have the FFCRA that they needed to think about. And so they were still trying to provide those same types of benefits. So they developed a administrative leave policy with our help that I think is really effective for that particular organization. For those of you who are fewer than 500 employees, and I know a lot of the folks on the phone fall into that category, you really do want to make sure that you're ensuring FFCRA compliance, and that includes emergency sick leave and expanded FMLA, and that you're tracking it right, both so that you know how much time they're taking, but also that you get that documentation, you're getting those tax credits, right? And so just because people are in encouraging people to report their illnesses or their time off that you're paying for in a way that's going to allow you to maximize your ability to get those tax credits. So most clients, again, you've probably already started this, providing some sort of policy resource, looking and saying, okay, this is an addendum to the handbook or a source of information that supplements the handbook right now. These particular policies will be modified on a temporary basis, and we'll let you know when that's no longer the case. But a policy resource, I would say that policy resource is also going to be the place where your control plan is going to be, as well as your sector-specific rules that we're going to talk about when we get into the details of that. Next slide, please. Testing. Many clients are thinking about employee testing, both mandatory and voluntary. So this is a big topic, and so let me just try to. We only have a little bit of a finite amount of time today, so I don't want to. I could spend 3 days talking just about employee testing and all the different rules associated with it. But bottom line, what it comes down to is you need to be thinking about employee confidentiality and privacy with respect to testing. That comes in really two forms. We want to think about privacy and confidentiality from the standpoint of disability discrimination in EEOC laws. Then we want to think about privacy employee privacy when it comes to state-specific laws. Those are not the same, and they're many times people understandably conflate the issues and conflate the analysis. When you think about it under the ADA, all right, the EEOC has come out and said, although medical testing is something that's very restricted in an ordinary situation with current employees, because we're in a pandemic and because there has been a determination through the CDC and the World Health Organization that there's a significant risk of harm that's posed to others in the workplace if someone comes into the workplace with the virus. Then because of that, we are going to say that testing, that direct threat that exists now, may not exist like in a month or two, or hopefully that would be wonderful for all of us, right? But it exists now. We're going to say that there is the testing is allowed. They first came out and said that medical testing in the form of temperature checks was allowed. And so I immediately thought, well, okay, that's actually not the most effective way to find out if somebody has been exposed to the virus. Certainly doing a COVID test is much more effective. So I'm not sure why they would say temperature testing is okay and not COVID testing, because the whole intrusiveness of it is a different issue. That falls under the state privacy laws. Just under the ADA, it made sense to me that they'd also permit viral tests. And in fact, fortunately, they came out later on, a couple weeks later, I'm losing track of time, and said that yes, viral tests are also okay under the direct threat analysis. So I'm quite comfortable that the testing is okay under the American with Disabilities Act. That being said, if you are doing testing or considering it, and you're thinking about a nasal swab as opposed to, well, actually any kind of testing, even a saliva test, you always want to think about whether the employee who's being asked to undergo the test may not be able to do so for some disability-related reason. So you always want to make sure that they know that they can potentially opt out of the testing as a reasonable accommodation. Other than that, the testing is something that's permitted. Okay, let's just move next to the state law privacy law, the state-specific privacy laws. In Massachusetts, we have a statutory right to privacy. What that means is that there's a balancing test, and it's a balancing of the employer's right to invade the employee's privacy, really, through poking and prodding and things like that, and the employee's interest in having that not happen to him or her, right? So what do I mean by that? Well, there are some case law that in the drug testing context that I think is most instructive. And in that, there's a case, the SJC case called Motorola versus Webster. And in that case, it's a case from the 90s. there were 2 employees who complained about having to undergo random drug testing in the workplace. And long story short, the analysis was that having a urinalysis, a forced urinalysis by an employer is in fact an invasion of privacy. You start with that, okay? But it can be justified, that invasion of privacy can be justified if the employer's interest in doing that test outweighs the employee's privacy interests. And the level of which the employee has privacy interest is, you consider things like the invasiveness of the test. Okay, so your analysis is certainly not nearly as invasive as a nasal swab might be, right? So in that case, they said, well, because there were some classes of employees where it was okay to do the urinalysis on a random basis, and others where it was not. And it was really whether or not the person was in a safety sensitive position. It doesn't fit exactly to this particular context, because I don't think we really think there are different classes of employees, except if there are certain employees that really it may be because of the nature of their job, it may be very difficult to keep them within 6 feet of others and wearing masks all the time. So, for example, so for those folks, there certainly would be more of an interest in conducting testing than other employees. So there is a balancing test, and you do want to think about that and talk to, counsel if you're deciding that you're going to impose a mandatory employee testing program. Okay, so I said I wasn't going to spend too much time on that, and I did probably spend too much time. So let's move to the next slide. Screening inquiries and contact tracing. This is easier, right, from a legal standpoint, although I am hearing from a number of my clients that they're finding that they find it's administratively more burdensome, that they're not sure how they're going to do that daily screening in a way that's going to keep that information confidential, because when you're asking people, and you are permitted to ask people about their diagnoses or their symptoms and whether or not they live with someone in their household has been diagnosed with COVID-19 and has symptoms, that information that an employer is soliciting from an employee is protected under the American with Disabilities Act. And so you do need to be careful not to disclose that too broadly, all right? So that being said, most clients, I would say, the vast majority are figuring out a way to conduct that daily health screening and making sure that it just goes to the director of HR and doesn't go more broadly than that, and that you dispose of the information. There's no real requirement that you keep it all the time, but that you put this as part of the daily work rule, that people have to certify that they don't have symptoms, that they have that they don't live in the household with someone with symptoms, et cetera. And we've developed a questionnaire that we're pretty comfortable with that tracks both the EEOC and the CDC on these issues. Okay, next, practices outside of the workplace. This is an interesting one. How much can an employer ask an employee about what he or she is doing outside of work if it really has nothing to do with work, except that the activity increases the risk of transmission, of becoming infected outside of the workplace and bringing virus back into the workplace? This is a hot topic, and one that I was on the phone with my employment group, my employment partners, and the rest of my employment group last night, and we spent a bunch of time just batting it back and forth, because I do think this is going to be the next thing. How far can you go? And this comes both in the form of apps, technology that you may require employees to wear or to carry their phone around, et cetera, that talks about their outside activities, and questionnaires where you're asking what activities they're engaging in outside of the workplace. Right now, we're very comfortable that you can ask people if they social distance, and if they wear a mask to work, if they're outside of the workplace. It's really getting beyond that. Did you go to Missouri this weekend? Didn't go to the lakes region, or whatever those kinds of questions are ones that are going to be more interesting from a legal standpoint. Contact tracing, to the extent that you determine that somebody has developed COVID and they have been in the workplace when they could have been symptomatic, then it's on the employers. It's the expectation, certainly, that the employer will then engage in contact tracing. What that means is that of course, the public health authorities will be doing their own part in doing that. And so notifying public health authorities is permissible and required to let folks know that there is COVID, but also engaging in employer tracing through interviews itself, right? Some employers are looking to tracking devices within the workplace, wearable devices in the workplace, to ask people to wear those so that that will do the contact tracing for them. So in other words, I have something on my hand, I wear it from the time I come into the workplace to the time I go out. If I am later diagnosed with COVID, the information that I can get from that wearable device, it'll do two things actually. When I have it on, if I'm within 6 feet of someone, it'll give me a signal that I should move, right? And the second thing it can do is it can say that if I am diagnosed with COVID, then who have I been in contact with during the incubation period, close contact in the workplace, by saying, because all the other employees have it on as well, and that really facilitates the contact tracing that you may be doing in the workplace. I think it's a pretty cool technology, and one that I don't have a lot of privacy concerns about, as long as it's only required in the workplace. Next slide. Okay, advising and employee concerns. So effective communication and posting requirements. We'll talk about this as we get into the part of the program that talks about the Massachusetts reopening order. But I do want to focus for a moment in this slide on employee complaints and what to do about those. There are going to be employees who are going to be afraid to return to the workplace. And there's going to be a return based on, claims about workplace safety. I expect there to be tension in the workplace. So my strong suggestion, after many, many years of dealing with, employee complaints and sort of, trying to get through these things, is that sometimes, particularly like with sexual harassment, sometimes employers would say, oh, try to work it out yourself and then come to us if there's really a problem. We shouldn't have to get involved in everything. I really think you have to get involved in issues here, and don't try to have employees work them out. This is so sensitive, and as we all know, there are different schools of thought on how much distance is necessary and appropriate, and there's going to be a clash in the workplace, and let's try to reduce that as much as possible by having sort of a communication czar within we keep saying there's like a task force czar, but then there are like mini czars within their categories. There should be someone who is the complaint person, someone who you really think is going to be good at that, who is available to deal with anything that comes up in the workplace related to the social distancing, disputes with coworkers, et cetera, et cetera. There is whistleblower protection to the extent somebody has made a complaint about workplace safety. There are a few steps as to whether it does need to be reasonable, but you want to be careful about taking adverse employment action against someone for making any kind of complaint, even if you think it's not really valid. Same thing with protected concerted activity. To the extent more than one employee gets together or is talking, even if it's one employee who's talking on behalf of other employees, then there's potential protection under the National Labor Relations Act, and so we need to be thoughtful about that as well. But one point to make on this is that the generalized fear of returning to work is not enough to allow someone to stay home. Okay, you can require someone to come to work even if they just have a basic fear of coming to work and becoming infected. If the person has a disability under the law, if they are vulnerable individual, as has been defined under the Return to Work, White House Return to Work, Open Up America Again guidelines, or the CDC's highly risky employees, then you may also consider giving what we're calling special accommodations, even if that person isn't disabled. But a generalized, I just don't want to come to work, I'm not comfortable doing so, is not something that you have to tolerate. You may decide as a company you're okay with that, and you only want people to come in that are comfortable, but you don't have to tolerate that. Okay, next slide. So I just mentioned the vulnerable individuals under the Opening of America Again guidelines. These include elderly individuals and individuals with underlying health conditions, such as high blood pressure, et cetera. You can see the words on the screen there. I also looked at the CDC's definition too, which is high-risk individuals. I believe I'm blanking on whether it's high risk. I think that's what it's called, high risk individuals. In any event, there are the two standards, and you want to look to those to determine whether or not somebody is in fact a person that would be more vulnerable coming to work. Importantly, you cannot ask them if they're a vulnerable employees, if someone's a vulnerable employee. You cannot ask someone if they are going to, or require somebody not to come to the workplace. All right, so let me repeat that again. You can't come right out and say, I need you to self-identify as being a person who has an underlying health condition or is an elderly individual. So because you can't come to the workplace if you fall within one of those categories. However, you can, and I suggest you should, offer people the opportunity to come forward and to request special accommodations if they fall into one of these definitions. So the questionnaire that we put together, we usually put at the bottom of it, if you are a vulnerable individual, as defined as, and we trace the language of the either Open App America guidelines or the CDC, and say, if you fall within this category, then you are eligible for special accommodations, and you should feel free to come and ask us about those. You don't have the same legal responsibility as you would to somebody who has a disability and is entitled to reasonable accommodations under the law. Okay, so there's two different things. If someone has a disability under the law, and many people who are vulnerable individuals will also have a disability under the law, but some will not. Some will only be vulnerable, but won't have a disability under the law. The ADA says that you need to engage in the interactive process and provide reasonable accommodations. There's no such law currently that says that you need to do that for vulnerable individuals or high-risk individuals for COVID, although it's highly recommended in all of the plans, the reopening guidelines, both at the federal and state level. Okay, next slide. Okay, finally, we get to reopening Massachusetts. I'm looking at my slide. I think I only have a few minutes. So there's quite a bit that comes from here. The reopening guidelines, I'm sure many of you have already had an opportunity to take a look. Please take a look also, if you'd like, if it's useful to you, at some of there are two client alerts that we've prepared. The first one is more general on the topics that we just covered. The second one is very focused on reopening Massachusetts. I think I've gotten a lot of positive feedback on it, mainly because within that client alert, we included a lot of links. So we'll say, this is what you have to do, and then link to the document that actually talks about what to do. Like, for example, you have to develop a control plan, and then it links to the template control plan, and then sort of tells you how to fill it out. So I think that might be useful for you to take a look at. The four-phased approach to reopening, of course, includes where we are now, which is start. Next, we're thinking about cautious, then vigilant, then new normal. Each phase, it says, will last a minimum of 3 weeks, and we may go backwards. I think all of us are super helpful that we just, even if we have to slow roll it, hopeful that we can slow roll it even a little bit, we don't have to go back. I think psychologically it's quite difficult to go back again, but it certainly is a possibility. Employers should be prepared for it. And we should be preparing our employees for it as well. There are key public health metrics that are going to be determined the appropriate phase at any given time. Next slide, please. Okay, great. Phase one, you all know this because it's already started, except for the offices in Boston, which are going to be open on June 1st. Although Mayor Walsh did indicate yesterday that he is, you probably all have heard, those of you in Boston offices, certainly there's going to be another task force. It's going to be helpful that he's going to be advising him on rules with respect to opening up Boston. Mayor Walsh has been quite vocal about his concern about the 25% number being too much too soon, and that Boston will get flooded with people of non-essential workers. Although certainly from the discussions I've been having, it feels like people, even if they're permitted to go back because of how difficult it will be to get everything ready, people aren't rushing back this week, even that first 25%. Okay, next slide. So what does every business need to do before you reopen? there are three basic things. You have to develop this written control plan that I've mentioned a couple of times. That needs to show that you're complying with, and I use all caps on the mandatory workplace safety standards because those are actually a document, right? There's a set of standards that you can find on the mass.gov website. You can also find, if you look at our client alert, links to those, which are the mandatory workplace safety standards, and it outlines, the basic things that you need to do. You also need to post employer, worker, and both employer and worker posters that provide notice of these standards. Those posters also can be found online. I really do think that the state did a very good job with helping employers be able to link to things and not have to reinvent the wheel in a number of categories, so that's great. The control plan, the template, I'm going to just go back to that for a second. The template is really very bare bones. But that's not all you need to do. You need to actually check the boxes in the template, and then you need to have the rules that are attached. And we'll talk about that in a minute, but those get attached to the control plan. Okay, post a compliance attestation poster that provides notice to workers that they're taking required steps. So those three things are a must before anyone can open business, regardless of the phase. Next slide. Sector-specific standards. You do need to really take a look at what standards apply to you. Many of my clients have labs, but they also have office spaces, so they need to look at both of those, right? And so each of those, and there's a lot of overlap, the 6-foot rule, things like that in the various sectors. But you still want to pull whichever ones. I'm saying to clients, look, the first thing you want to do is figure out what applies to your business, marshal all the documents together and the advisories, as well as the CDC guidance, the OSHA guidance, and then certainly you want to look at these three things for each of your workplace specific area, which is our sector specific area, the safety standards themselves. Well, you want to get the mandatory standards, then you want to get the sector specific workplace standards, sector specific protocol summary, and then the checklist. There is overlap, okay? But the checklist, I think, is really useful because the standards are just, they're rule-based. The summary just kind of overlaps. It's something that people can read if they don't like to sit down. And I'm, a lawyer used to reading a lot of rules, but some people don't want it. They'll lose something if it's too dense. So the summary is helpful for that. The checklist is really your operational document. So to be walking around saying, did I do this? Did I do that? And so I have a picture in my mind of like the task force czar in each office really going around and pulling out their sector specific checklist to make sure everything's there. Next slide. Okay, office spaces, you all know this, I'm sure, that it's no more than 25% of, and I get this question a lot, 25% of what? The maximum occupancy level of any certificate of occupancy, right? So I've heard now, and this is something that's sort of outside of the employment law world, but I've had to ask the question, of course, is that the tenants have a certificate of occupancy as a tenant that will tell you how many people you can have in your particular part of the building if you don't own your building. So you can look at that, and it's 25% of that, or it's 25% of the business's typical occupancy as of March 1st, 2020. It doesn't say the lesser of, it says, it's kind of an interesting way that this has been, it's caused a good deal of confusion, I will say. But those are the actual, that's the actual definition there in the screen that you need to look at when you're figuring out your 25%. Okay, in addition, a business in the office sector must do a number of things. You have to develop what's called a COVID prevention plan. All right, that's different from what others need to do. And that provides for isolation, contact tracing, and communication policy applicable to when someone is in fact diagnosed with COVID-19 or comes in close contact. So you're not scrambling. We're certainly hopeful that this is going to be something that's not going to happen frequently, but I'll be surprised if most of the folks on this phone, if you haven't already, won't be dealing with COVID in the workplace. So rather than trying to scramble and say, what do we do now? How do we do the contact tracing? So if you have a plan in place, you can pull it out. Say, we've thought about this. It gives your employees comfort. You know where to go, and you're not losing precious time. You also have to develop a plan to log everyone in who comes in contact with the website and to enable contact tracing, including those who are visiting solely for material drop-offs, which is, that's just a login. Again, more of an administrative duty, but it is something that does need to be done to satisfy the standards. Next slide, please. Workplace specific rules. Okay, so we can talk about what you need to do as a general matter. You can pull things off the website, but how does that really work in your particular workspace? Well, it certainly isn't, it's not customized for your workspace. And this is where I said the control plan requires more than just, printing out the template. You really need to become knowledgeable about all the standards, and you need to do a walk around in your workplace and you day in the life of everyone, and go in and say, okay, what does it mean when you walk in the building, and how does the person walk upstairs, and how does that all come back, and you develop those work rules. And as I said here, you really want to be thinking about physical space, behavioral habits, and workplace culture. That's really what, in my mind, is going to be important. And all of those things need to be considered, because otherwise you're just going to have an unsuccessful plan, and that would be really detrimental to the reentry process. Okay, next slide. Communicating and training. You do need to both communicate and engage in training with employees. So the posting of the work group posters, as I said, those are on the website. You can get those. That's an easy thing to do. Get that up, post broadly everywhere. Just keep putting things up all over the place. And also you need to make sure you have, and this is going to deal with things like hygiene, washing hands. You need to make sure people have the opportunity and to wash their hands, know what the protocol is with respect to using restrooms, things like that. There's just a lot of detail that's gonna be necessary, in that you might want to be posting signs about that as well, not just giving people workplace rules because they may not read them all. Okay, so you also want to do that preparation plan I mentioned, and then the up-to-date safety information, including hygiene, social distancing, self-screening, etc., proper disposal of face masks, rules in elevators, lobbies, break rooms, and the use of the configured workspaces. This is just so much, it's just such a different way of coming to work that you're going to have to really sit down and have someone, this is another person, I think, or maybe it's the same person on your task force who's going to be responsible for really digging down deep, knowing the details, and then communicating effectively those details to your employees through training programs. The training programs really should be based on both what we have under the state rules, but also thinking about CDC and OSHA guidance. Again, pull those initial resources, have them at the ready, and really be able to try to develop the program. Like, for example, they say how to use a face mask. No one really knows how to use a face mask, most of us that work in offices, but the CDC does, and they put rules out, information about it, so we rely on that instead. Okay, next slide. Monitoring compliance, this is the next big part, right? Who's going to be policing the organization to make sure that folks are really following the rules? This is going to be tough, right? It's on the line, you put it on the paper and you say, okay, that's all right. But many of us have taken great pride in the fact that we work in places that we trust individuals. Use your judgment, and that's, we're all adults, and let's get together and collaborate and connect and all those things. And now we're saying no connecting, yes, collaborating, but doing it in a distant way. And then you can't be near each other, and you can't, we want less socialization. It's just like a complete reversal of what many of us have done. And I think when we get back into the workplace, into the office, we're really going to be missing the old ways. And so there's got to be someone who has to be a bit of the bad cop on this, and the bad cop in a way that's not going to, cause just a huge clash and have all the workplace culture work that you've done over the years go down the toilet. So, figuring out the tone of how the monitoring compliance will take place. And again, I mentioned this here, I said at the beginning, but the tone at the top really matters. This matters for any behavioral issues. You all know this in the workplace. It matters when I spend a lot of time talking about harassment and discrimination. It matters a lot about when it comes to talking about compliance with these work rules. The leaders of the organization need to be wearing masks. It can't be, there's no exceptions on that, etc. Okay. And then I already mentioned this before, which is developing a procedure for where employees can raise the concerns. Next slide, please. Okay, finally, enforcement. What is this? We've talked about that there are a lot of rules that you all need to follow. What happens if you don't? Well, the worst thing that happens if you don't is that you have your virus in the workplace that you didn't otherwise, that you could have avoided. I'm not saying that because you have a virus in the workplace that means that you haven't followed the rules. It can happen anyway, of course, right? But if you don't want to be in a situation where there's disease that's developed in the workplace because you've been too lax or you really haven't followed the rules as closely as you wanted to. But what else is there from a legal standpoint? Where's the stick? The Commonwealth Department of Labor Standards, the Commonwealth Department of Public Health, municipal boards have all have the authority to enforce the order. I certainly have cease and desist orders already with fines, but I haven't actually seen anyone get a fine. I've seen them get the cease and desist order and then do something different and the fine went away. So fines may be issued and injunctions may be enforced for non-compliance. However, if those of you who were able to had an opportunity to watch the presentation, the press conference on May 18th, when the reopening order was first issued and all this guidance came out, you know, what they said there is that practically speaking, that there's the expectation that the violation of the requirements will most likely come to the attention of the enforcing agency through complaints made by employees and customers. And that it's not like someone's going to be going around and knocking on doors. Again, does that mean that you don't take these as seriously? Of course not. This is incredibly important, life and death. But it is something that we don't at this point expect that there'll be a lot of folks going around and looking for violations. But I wouldn't underestimate the power of employees to cause significant headaches with whistleblower activity here. And then they're protected, and then it becomes complicated for all the reasons that it's always protected when you have a whistleblower on the work, but it's always complicated when you have a whistleblower in the workplace. Okay, so it's 10:41. I spoke as quickly as I could to get through all those slides. There's really quite a bit to cover, but I want to make sure we take an opportunity to answer any questions.
Great. So thank you again so much, Meredith. And we are encouraging everyone to ask your questions via the Q&A tab at the bottom. So the first question that we have is, do the posters need to be laminated or put inside sheet protectors? You know, very practical questions.
Yeah, it's a practical. I actually don't. So it's kind of interesting because you print it out, right? But I would think that when you see posters, they are almost always laminated, but I have not seen a requirement that it is that be laminated. It would be my suggestion that if you can get it laminated, you do. But the most important thing, I think, from the government standpoint is that you're communicating this. So whatever the effective communication is, even if you have to put a piece of paper up, you know, maybe larger font, whatever, just put a lot, don't, you know, put the posters everywhere you can is, I think, the idea, without making it so much that you feel like people aren't going to read them anymore because it's overwhelming. But I think more is sort of the theme when it comes to communicating with employees through posters.
Great. And someone else actually also asked, what if an employee has a family member who is vulnerable or considered high risk?
Yeah, for sure. That's an excellent question. So let's talk about a decision tree quickly. If somebody wants an accommodation, they come and they say, I want an accommodation I don't want to have to come to the workplace, for example. The first thing you say is, okay, does that person have a disability under the law? Do they have a medical or physical, mental health condition or physical condition that substantially limits their ability to perform one or more major life functions, right? We all know that that's the basic definition of a disability. And if the answer is no, they don't have that, this is, you know, but so we don't really have to give reasonable accommodation, because it's only if someone has a disability that you have to consider giving reasonable accommodations. The next part of the decisional tree is, okay, well, they don't have a disability, but they are a vulnerable employee. Let's take, for example, somebody who has asthma, but they're not, although I think CDC may have taken moderate asthma off the list of high risk individuals, but they have a condition that they're perfectly able to, diabetes, for example, controlled diabetes, a young 25-year-old with controlled diabetes, that they really don't have any kind of, it doesn't impact their life very much at all. Let's say that's the case, and they determine that they're not actually disabled. And maybe diabetes is most of the time is someone who has a disability. So I'm thinking of, you know, there are a number of people who are vulnerable individuals. Oh, perfect example too is someone who's older, right? That's somebody who is identified as being someone who's over 65, is a vulnerable individual, but not somebody who has a disability. You do not have to accommodate under the law somebody who doesn't have a disability, even if that person is a vulnerable individual, all right? But the federal and state guidelines are suggesting that you consider doing so. So most employers are considering doing so, but you're not required. Then you get to the next part of the decision tree. You say, okay, this person doesn't have a disability, and he or she is not in a vulnerable population. So therefore, we don't need to do anything. Oh, but wait a minute, the person has someone in their household who is in a vulnerable, either has a disability or is part of the vulnerable population. Let's say someone has a child at home who has cancer, or they're taking care of their elderly parent and they have to be, hands-on when they get home from work. How do you deal with that? There is no legal obligation to provide an accommodation in those circumstances. Again, many companies are making the policy judgment that they want to give people the opportunity to self-identify as living with someone with a vulnerable in the vulnerable population, and they will consider special accommodations under those circumstances, but it is not required.
Great, thank you so much. And Chris had a question. Can you recommend a right size approach for a company of only 8 employees, where obviously a significant task force and the czars that you were talking about isn't really feasible?
Yeah. You got to be like the czar of everything. Yeah. If you're going to bring people back into the office, you do need to still do the same basic set of rules. They are not reduced based on the number of employees. It just, it is what it is. I do think that if you use the guidance that's on the government website, oh, I know what else. If you're in Boston, I read this morning that there's going to be a fund that helps employers with very small businesses get into compliance. But I do think that not that you learned everything in today's session, but between today's session, the client alert that really takes you step by step, and the links to that, you really should be able to do this without too much difficulty. If there are only 8 employees, there are only 8 people to worry about. So it's it's a smaller issue than if it's a larger company and you really do need to worry how people are getting off the elevator, someone else has to worry about employee complaints, etc. So I think it should be doable, but your obligations are not lessened because you're a smaller employer.
Great. We have a question that came in actually through the chat, and it says, if your company is an essential employer who has not completely closed down, do you still need to provide all this documentation?
Yes, you were supposed to do it by the 25th of May. Yep.
Perfect. Quick answer, I like it. Another person asked, the building certificate of occupancy is much higher than what they had on March 1st. For the 25% limit, can they default to the higher number? Also, do you expect that 25% to be increased?
Good question about the increase. And on the building occupancy, there's been a lot of confusion about this, but I think you can default, as long as you make a good faith determination that you're hitting, it's disjunctive, right? Either one of those, then you should be okay. Most of my clients I've been talking to, it's not the building occupancy, it's just the office space occupancy, which is maybe what the participant is talking about. But yes, I think you can, if you have a good faith basis of using either one of those two things, look at the slide, then you should be okay. It is very interesting that it doesn't seem to have a sliding scale upward, right? It's like what happens at phase 2? It doesn't say that we go from 25% to 50%. So I think unless there's an amendment to these rules, which hopefully things will be going so well that Charlie Baker will be able to come out and say, oh no, we don't mean 25% has now been lifted and has been changed. As I say, these are fluid rules. They start with something and then they move from there. Otherwise, we're really looking to phase 4 until we go beyond 25%, at least under the current rules. And remember, each phase is at least 3 weeks.
Great, thank you. And another practical question. So in regard to wearing masks, do employees need to wear the masks when they're sitting at their desk and they're 6 feet from each other?
No, they do not. They need to have masks at all time when they can't be within 6 feet. That means within the hallways, et cetera. You do need to have a mask with you. But if you're sitting in your desk and you are apart from, you are not within 6 feet of anybody else, then you do not need to wear the mask the whole time.
Great. And then about eating and drinking, obviously.
That's under the Massachusetts guidelines, by the way. Under the Cambridge guidelines, I should have looked at those before today's call, but they're more stringent. And I don't know that there's a ability to take the mask off when you're sitting in your office. I would need to look at that again, but that's under the Massachusetts rules.
Great. So that just gets into what you said at the beginning, and make sure you look up the specific documentation for your community.
Yeah. Yep.
And about employees who go back and forth between labs and office spaces, can they wear the same mask?
There's no, I don't think there's as much detail. I'd have to look at the laboratory-based sector-specific guidelines on that. I read somebody's guidelines last night. They had a really interesting, I thought an excellent, control plan that they put into place that basically said when someone comes in, they take off their mask, they put it in their cubby, they don't use the same mask within the workplace, then they keep one mask on during the workplace, and then if they went to I think it was the same mask in the lab and in the office in that particular situation, but it was a different mask from outside to inside, which, we don't have anything that's that specific, at least in the guidelines that I've read, that would tell you that you have to take the mask off between those two locations. But again, I would defer to the sector-specific guidelines on laboratories to be sure that I've got that exactly right.
Great. And I think we have the last question here, and it says, my company has 5 employees and we rent space from another company. They're in the process of setting up their protocols. Does my company legally have to do the same exact thing, which is almost a duplication of effort?
Well, so I have a number of clients that are in that situation, and I'm really advising coordination. So whether you have to do exactly the same thing, you have to put into place a control plan. You have independent legal obligations, but it does seem silly to have a duplicate efforts in that regard, in that you could do a task force that is made up of someone from both of the companies in the shared space and make sure that everyone's following the same rules. I think it's going to be almost impossible to have shared space and have different people having different rules. I'd highly recommend that folks coordinate on that and work together on it. Otherwise, it seems like a recipe for a disaster. So if the other company is much larger and has better resources, then they're really going to town and doing all the control plan and having all these meetings and setting up the task force, and you're just a really small employer that's going along with it. First of all, if I was representing the larger employer, I would make the smaller employer agree as a condition of continued sharing of space to comply with this. But I would ask them to comply first, and then see if they said no. I'd have to look at the lease to find out if I could require it for safety purposes. So why get into any of that and just say at the beginning, let's work together on this, or you let us know what we're going to do and we'll follow it. If you're small and don't want to really get into the details.
That's a great suggestion. Well, Jennifer, thank you so much. And before we leave, I'm actually going to enter the 2 links into the chat box. So if anyone wanted to see the documents on Goodwin's website, you can look at the chat box and click those links so they open before the webinar ends. Jennifer, thank you so much for this fantastic and really well received. I'm sure everyone learned more than they ever imagined today. So thank you so much.
Thanks, everyone. Have a great day. We'll see you soon. Bye.